Section 13 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 6. Tribal Custom of the Franks and of the Tribes Conquered by the Merovingian Kings. Part 2. 2. The division of classes as shown by the amount of the Vergeld. Turning now to the amount of the Vergeld, something may be learned of the division of classes under the Lex Salica. Title 41 fixes the amount of the Vergeld of the typical freeman who is described as the Frank or the barbarian man who lives under the Lex Salica. The amount, as throughout the Lex are all the payments, is stated in so many denarii and so many solidi, 8,000 denarii, i.e. 200 solidi, and that the Frank or barbarian living under the Lex Salica was the typical freeman is shown by the title de debilitatibus, which fixes the payment for the destruction of an eye, hand, or foot at 100 solidi. Half the Vergeld is the highest payment for eye, hand, and foot ever exacted by the continental laws, and 100 solidi certainly cannot apply to any greater persons with a lower Vergeld than 200 solidi. Title 41 is as follows. Si quis ingenu Franco o barbarum, qui legum solega vivit, occiderit, cui ferit ad probatum, 8,000 denarii, qui fac soldati, 200 culp jude. If anyone shall kill a freeman, a Frank or barbarian man who lives under the Lex Salica, let him whose guilt is proved be judged to be liable for 8,000 denarii, which make 200 solidi. As this clause probably dates before the issue of Merovingian solidi of diminished weight, the 200 solidi of the Vergeld may be taken to have been at the date of the law 200 gold solidi of imperial standard, so that the Vergeld of the Frank or the free barbarians living under the Lex Salica originally, when paid in gold solidi, was neither more nor less than the normal Vergeld of a heavy gold mina. We learned from clause 2 of the same title that if the homicide was aggravated by concealment of the corpse, the composition was increased to 24,000 denarii, or 600 solidi, and that the Vergeld of a person in trus dominica was again 600 solidi. The royal official thus, as in several other laws, had a triple Vergeld. Then lastly, under the same title are 3 clauses, describing the Vergelds of the Romanus Homo Coviva Regis as 300 solidi, of the Romanus Homo Possessor as 100 solidi, and of the Roman Tributarius, in some texts 45, and in others 63, 70, and 120 solidi. In Codex 10, the Romanus Possessor is described as the man who in the pages in which he lives res proprius passadet. The natural inference from these lesser Vergelds is that the Gallo-Romans were not living under the Lex Salica, but under their own Gallo-Roman law, with Vergelds 1/2 the amount of those of the Frankish freemen. Another of the 65 titles, viz. 54, gives a further set of Vergelds. The Vergeld of a Graphio is to be 600 solidi, that of a Sacabaro or Ob Graphio, who is a pure Regis, 300 solidi, and that of the Scarborough, who is an ingenuous 600 solidi. The Sacabaro was apparently the lowest in rank of judicial officials except the Rackenburgers, and the clause adds that there ought not to be more than 3 Sacabarones in each Malberg. We may conclude from these statements that the Vergeld of the freeman living under the Lex Salica being 200 gold solidi, the higher Vergelds up to 600 solidi, were the threefold Vergelds of public officials, i.e., threefold of the Vergeld of the class to which they belonged. The Vergeld of the Sacabaro, who was a pure Regis, was 3 times that of the Romanus Possessor. the Sacabaro, who was an ingenuous, had a Virgeld 3 times that of the ingenuous living under the Salic law. We are thus brought into contact with an interesting question. These laws, made after conquest and settlement on once Roman ground, ought to be good evidence upon the tribal method of dealing with strangers in blood, i.e., in this case, the Gallo-Roman conquered population. And these clauses seem to show that half Virgels only were awarded to them under Salic law. Monsieur Fustel de Collinges held indeed the opinion that the term Romanus of the laws was confined to the freedmen who had been emancipated by process of Roman law. But here the contrast seems to be between Franks and barbarians who live under Salic law on the one hand, and the Gallo-Romans, whether freedmen or Roman possessors, living under Roman law on the other hand. We shall come upon this question again when the Ripuarian laws are examined, and need not dwell upon it here. It is interesting, however, to notice that in Codex II, Title 41, the Malberg clause, on the clause regarding the Virgeld of the Romanus Tributarius, is Euali Leodi, which Kern 208 explains to mean the Virgeld of Walla, the well-known name given by Teutonic people to their Gallo-Roman and Romanized neighbors. 3. Tribal rules of succession in Terra Salica. The question of the payment of Virgeld is now generally admitted to be distinct from that of inheritance in land. The persons who receive and pay their share of the Virgeld are those who would have taken part directly or indirectly in the feud. They are not confined to the expectant heirs of the slayer or the slain. If we are to learn anything directly upon the question of the method of landholding under Salic custom, it must be, not from the clauses relating to the Virgels, but mainly from the title 59, De Alidis. It is the next title to the De Cerna Cruda, and can hardly be passed by without some attempt to recognize the bearing of its clauses upon the present inquiry. Its text is very variously rendered in the several manuscripts, and it has been the subject of many interpretations. But if it may be legitimate to approach it from a strictly tribal point of view, it will not be difficult, I think, to suggest an interpretation consistent with what we have learned of tribal custom from the Cimbric example, and therefore worthy, at least, of careful consideration. According to Codex I of Hessels and Kern, the clauses are as follows. 1. Sequis mortius ferit et felonius non demersit. Si mata sua superferit ipsa in hereditatem succedat. If anyone shall have died and not have left sons, if his mother shall have survived, let her succeed to the inheritance. 2. Si mata defurit et fratum, aut soribum demiserit, ipsi in hereditatem succedant. If the mother shall not be surviving, and he shall have left brother or sister, let them succeed to the inheritance. 3. Tunc si ipsi non ferent, sona matris in hereditatem succedat. Then, if they shall not be surviving, let the sister of the mother succeed to the inheritance. 4. Et inter de illis charitionibus, quinque, proximor ferit, illi in hereditatem succedat. And further concerning these generations, whichever shall be the nearer, let it succeed to the inheritance. 5. De terro vero nulla in mulier, heredis non pertibet, sed et virilum secum, leg sexum, de fratris verent tota terra patridat. But concerning land, no inheritance shall pertain to a woman, but to the male sex, who shall be brothers, let the whole land pertain. The last clause in Codex 10, heralds, is amplified as follows. 5. De terra vero salica, in malarium nulla portico hereditatis transit, sed hoc virilis sexis aquavit, hoc est filia in ipsa hereditate secunt, sed ubi inter nepotens, ut pronepotis, post longum tempus ye abode terri contentio succedere, non per stirpis, sed per capita dividatur. Concerning, however, terra salica, let no portion of the inheritance pass to a woman, but let the male sex acquire it, i.e. sons succeed to that inheritance, but where after a long time dispute may arise between grandsons or great-grandsons concerning the allot of land, let the division be not per stirpes, but per capita. Now, in the first place, what is meant by the term allod? In the lex salica, it occurs again in Title 99, de revis in alloda patris, which relates to a dispute about the right to a certain thing, as to which the decision turns upon the proof that can be given by the defendant that he acquired the thing in allodi patris. He has to bring 3 witnesses to prove quod in alloda patris hoc invenisset, and 3 more witnesses to prove qualita pater suis res ipsis invenisset. And if after failure of proof and the interdiction of the law, the thing be found in his possession, he is to be fined 35 solidi. From this clause, the inference must apparently be that the allot of the father was the whole bundle of rights and possessions, personal as well as real, which passed to descendants by inheritance. Indeed, it seems to be generally admitted that in the title de allodus, all the clauses except the last apply to personal property, and only the last to realty. There are titles de allodibus, both in the Ripuarian law and in that of the Angi and Verini. In both laws, the allod includes personalty, and the latter defines the personalty as pecunia et municipia, thus reminding us that the personalty of the allod mainly consisted of cattle and slaves. In the title de allodibus of the Ripuarian law, the hereditary or ancestral character of the allod is emphasized by the application to it of the words hereditas aviatica. There may, however, be some doubt whether the term hereditas aviatica included the whole allod or only the land of the allod. Regarding, therefore, the allod as in some sense a bundle of rights and property, let us try to consider these clauses with a fresh mind in the light of what we have learned of Cymric tribal custom. Under this custom, speaking broadly as we have seen, daughters did not share in the landed rights of the gwali. They received instead of landed rights in the gwali their gwadal, or portion, mostly no doubt in cattle, and they were supposed with it to marry into another gwali, in whose landed rights their sons were expected to share by paternity. If women inherited landed rights at all, it was exceptionally in the case of failure of male heirs, and then only so that their sons might inherit. The heiress in such a case, under Cymric as well as Greek tribal law, was in quite an exceptional position, and as we have seen in Beowulf, the sister's son might be called back into the mother's family to prevent its failure for want of heirs. The exclusion of female successors from terra salica is therefore quite in accordance with tribal custom. That the clauses as to personalty, de allodus, were modifications of ancient Salic custom, made in favor of females, is rendered almost certain by the position of the last clause as a saving clause, apparently inserted with the object of protecting the rights of the sons in the land of the allod, by preventing the application to it of the previous clauses. Codex 1 does not describe the land as terra salica. It is content to protect land without qualification from the application of the previous clauses, which, if applied to land, would transgress against tribal custom, and the same may be said of Codices 3 and 4. But in the Codices 5 to 10, and in the Lex Emendata, the words terra salica are used. This is a point of importance, because it goes far to show that the whole of the land of the allod was terra salica, and protected by the saving clause from participation by females. The use of the word land alone in Codex 1 forbids our thinking that part of the land of the Alad was terra salica, and the rest not terra salica. And this consideration seems to show that to import into the clause any explanation of the term derived from the word sala, so as to confine its meaning to the house and hofland, or the väterliche Wohnhaus, as Amira and Lamprecht would do, would be misleading. The homestead of the chief of a tribal family holding on terra salica may, like the Roman villa, have passed by various and even natural stages into the herengut, or terra indominicata, of later manorial phraseology, and the term terra salica may have clung, as it were, to it. But to reason backwards to the lex salica from the instances of its later use given by Gerard in his sections on the subject seems in this case, as I may venture to say so, to be reversal of the right order of inference. Lamprecht carefully guards himself against the view that the terra salica of the lex was as yet a herengut, and Gerard, in his careful sections on the subject, admits 3 stages in the evolution of the terra salica. 1. Le senti dépetat de la maison de Germain. 2. Le terra demans seigneurial. 3. Simplement la terre possédée en propre, quelquefois donner un tenor. This may, in some sense, fairly represent the line of evolution subsequently followed, and I have long ago recognized the embryo manor in the Germania of Tacitus. But for our present purpose, this does not seem to help to an understanding of the term as used in the lex salica. When all the codices are taken together into account, terra salica seems to include the whole of the land, or landed rights of the Alad. From the whole, and not only the chief homestead, the succession of females is excluded, and it is the whole, and not the chief homestead only, which is to be divided between the nepotes and pro-nepotes of the deceased tribesmen. Approaching the lex salica as we are doing, from a tribal point of view, we seem to get upon quite other and simpler ground. The emphasis laid in the lex salica upon the distinction in social status between persons living under the lex salica and those living under Roman law suggests that land held under the lex salica was not held under the same rules as those under which the Romanus possessor held his res propria. It would seem natural, then, that terra salica should be land held under Salic custom as opposed to and held under Roman law. And if this be the simple rendering of the term terra salica in the lex, then returning to the likeness of the Salic Alad to the Cymric family, holding some likeness might be expected in the rules of succession to the land of the Alad when compared with the Cymric rules of succession to the Tir Gwellic, or family land of the Gweli. We have seen that in the Gweli the descendants of a common great-grandfather were kept together as a family group till, after internal divisions between brothers and then between cousins, there was at last equal division of landed rights between second cousins, i.e., great-grandsons of the original head of the Gweli. The fact of this right of redivision at last between great-grandchildren was apparently what held the family group together till the 3rd generation. The last clause of the De Alitas, even as it stands in Codex 1, coincides with Cymric custom insofar as it excludes females from landed rights and confines inheritance in the land of the Alad in the first instance to sons, qui fratris fuerit, and when at last later codices call the land of the Alad terra salica, and the addition of Codex 10 is taken into account, the evidence becomes very strong indeed that under Salic custom, the land of the Alad or terra salica was held as a family holding, and, like the land of the Gweli, divisible, first between sons, then between grandsons, and at last between great-grandsons. But when among grandsons or great-grandsons contention arises after a long time concerning the allot of land, the lands of the allot should be divided, not per serfs, but per capita. The later the date at which this sentence was added to the final clause of de allitis, the stronger becomes the evidence of what ancient Salic custom on this matter was. Assuredly, the object of these words is not to introduce a new principle. They obviously describe ancient Salic custom in order to protect it. And how could a division per capita amongst great-grandsons take place unless, as in the Cymric Wely, the holding of Terra Salica had during the whole period of the 3 generations been kept in some sense together as a family holding? It would be unwise to press analogies between Cymric and Salic tribal custom too far, but I have before pointed out that a system of burgels, to which paternal and maternal relatives each individually contributed their share, seems to imply an original solidarity of kindred, which must, wherever it was fully in force, have been connected with a corresponding solidarity in the occupation of land, together with its complement, an individual ownership of cattle. And in the light of the de allitis, it does not seem unlikely that it may have been so under ancient Salic custom. If the foregoing considerations be accepted, may we not recognize in the term terra salica, as at first used, a meaning analogous to that which Professor Vinogradov has recently so brilliantly given to Anglo-Saxon term folkland? In both cases, surely it was natural that there should be a term distinguishing land still held under the rules of ancient tribal custom from land held under the Romanized rules of individual land ownership. It is not necessary to do more than allude here to the various clauses of the Lex Salica from which the existence of individual holdings is clearly to be inferred, if, from the single mention of terra salica and its ultimate division among great-grandsons per capita, the continued existence of tribal or family holdings held still under Salic law may be legitimately inferred. It is, at least, equally clear that the Romanus possessor, who lived and held his possession as res propria under Roman law, also existed, and if so, the 2 classes of holders of land must often have been neighbors. The vicini, qui in villa consistant, of the title de migratantis, 45, may some of them have been of the one class and some of them of the other. The objection of a single person living under Salic law to the interloper who would have a new meaning and become very natural if the conflict between the 2 systems were involved. And when we have reminded ourselves of these facts, the title de un qui de parentia tolle volt, to which allusion has already been made, which enabled the tribesman, by the somewhat theatrical action of breaking the 4 sticks of alder over his head, to cut himself loose from his parentia, takes its proper place as evidence of the temptation which must have been beset the young tribesman in close contact with Gallo-Roman neighbors to free himself from what had come to be regarded as a bondage, and to take an independent position as an individual under the new order of things which was fast undermining the old. Besides the title de allitis, there is another source of information which must not be overlooked, viz. the Edict of Chilperic, A.D. 561 to 584. This edict appears to have been issued soon after the extension of the Frankish boundary from the Loire to the Garonne, and specially to apply to the newly conquered district. This conquest would necessarily extend the area within which Salic settlements would be made among non-Salic neighbors, and multiply the cases in which even a Salic Frank might find himself less securely surrounded by kinsmen than of old. Under these altered circumstances, instances would become more and more frequent of the close neighborhood of tribesmen still holding under Salic custom, and strangers living under Roman laws of succession. The clauses of the edict seem accordingly to be directly intended to prevent lapsed interest of Salic tribesmen in land from falling to the vicinity when there were brothers or female relations surviving. In old times, in purely Salic settlements, lapsed interests must usually have become merged in the general rights of the kindred, the vicinity being kinsmen, and no harm might come of it. Landed rights would seldom have passed away from the kindred, but as the stranger element increased in prominence, the kindreds would more or more suffer loss. Hence probably the extended rights given by the edict to female relatives. It allows them to succeed in certain cases so as to prevent the land, or, as we should rather say, the landed rights, from lapsing to the vicinity. Clause 3 is as follows. Simile modo placet acet caveat, et si quemque vincinis habens a filios aut filias post albitum suum superstatus fluit, quandi fili et vixer in terra habeant, sicut et lex salica habent. Likewise we will, and declare that if anyone having vicinity, or sons or daughters, shall be succeeded to after his death so long as the sons live, let them have the land as the lex salica provides. So far evidently no change is made, old custom still holds good. But in the rest of the clauses a modification is made evidently to meet altered circumstances, and specially to shut out the vicinity. Et si subito filia defuncti ferunt, filia simile modo accipat, terras ipsus, sicut et filia si vivi fusunt et habescent, et si moritur, frata alla superstudis ferit, frata terras et sipitit, non vicini, et subita frata morens, frata non deliquitit supersitum, tunc soda et terra ipsa exidat possidenda. And if suddenly the son shall have died, let the daughter receive those lands, as the sons would have done had they been alive. And if he, a brother, should die and another brother should survive, let the brother receive those lands, not the vicinity. And if suddenly the brother shall die not leaving a brother surviving, then let a sister succeed to the possession of that land. The remainder of the clause is very difficult to construe in the imperfect state of the text, and is not necessary to dwell upon it. It seems to apply to newcomers, qui adventiet, and their rights inter se. We have then in these clauses an allusion to ancient tribal custom, as well as to the change made necessary by the new circumstances. The implication is that under the rule of ancient custom, on a brother's death without children, his brothers did not succeed to his land, but the vicinity. Now the brother is to succeed, not the vicinity. At first sight this seems unnatural and unlikely, but it ceases to be so if we may regard the allot of terra salica as a family holding under conditions somewhat like those of the Gweli. For under Cymric custom, the brother did not succeed to the childless brother as his heir. The co-inheritors, as far as second cousins, were his heirs. In other words, the lapsed share went to his vicinity, but they were the kinsmen of his own Gweli. Nor did a brother succeed to his brother's da, and the grazing rights and homestead connected with it. He had received this da, as we have seen, from his chief or kindred by kin and descent, i.e. by tribal right in his kindred, and therefore, if he should die without children, his da and everything he had by kin and descent went, not to his brothers, but back to the kindred or the chief of kindred from whom he received it. If the son die after 14 years of age and leave no heir, his argud is to possess all his da and to be in place of a son to him, and his house become a dead house. The lapse of landed rights in family holdings to the kindred was one thing. Their passing out of the kindred to vicinity, who were strangers, would become quite another thing. When, after a time, let us say under cover of the title, divide gratibus, or under extended conquest, others, perhaps Romani possessories, had taken places in the villa, side by side with the tribesmen living under the customary rules of terra salica, or when Salic Franks had settled among strangers, the new element would have to be reckoned with. In the clause, divide gratibus, the protection of ancient Salic custom was sought by the exclusion of strangers at the instance of a single objector from the stellar Salica. In the Edict of Kilperic, on the other hand, the presence of stranger vicinity was taken for granted, and the protection of terra salica sought by extending the right of succession to brothers and females, so that at least fewer cases might raise of lapsed inheritances falling away from the kindred into the hands of the vicini who might be strangers. The breaking up of tribal custom thus was not all at once, but by steps. At first terra salica was limited to men, then female succession was allowed, and lastly, in default of kindred, stranger vicini under certain conditions were admitted to the lapsed inheritance. End of section 13.